Good morning, everyone. My name is Liz Kukla. I'm the Secretary of the Board of Zoning Appeals. I'm going to read the preamble for you this morning. Maurice, if you could change the slide. In compliance with notification requirements of the city's open meeting law under COVID-19 emergency declaration, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that call-in users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube public view. We have provided a link to the meeting for those who wish to speak on a particular case via our website and email. We've also received emails from those who have provided written comments on a particular matter. Back to you, Madam Chair.
Thank you, Liz. Go ahead and call the roll, please.
Okay. Mr. Donovan.
Here.
Ms. Barnes. Ms. Faith.
Here.
Ms. Britt.
Here. All right.
Madam Chair, we have a quorum.
Thank you. Let's call this thing going. All right. Okay, good. So no postponements today. I did see that Councilman Kelly logged on today, so we'll start with his case.
All right.
Good morning.
You're muted, Alana.
Boy, I read all that and no one heard. So sorry. So sorry. So we'll begin with calendar number 21-1114 at 4106 Pearl Road. Mahil Saeed, owner, proposes to erect a 2,200 square foot bank building and a 15-space parking lot in a G2 local retail district, business district, and an urban form overlay district. The owner appeals for a relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record.
Thank you, Ms. Faith. Mr. Donovan, can you swear everyone in, please?
Yes. Anyone who wishes to provide testimony to this case, kindly raise your right hand. I'm going to spell out a statement. I'm looking for a response of "I do" with your name. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do.
I do.
Your name?
Kevin Kelly.
Okay. Anyone else?
Tony Coyne.
Jeff Castle.
Okay. Anyone else? Hearing none, we go to history.
Thank you, Mr. Donovan. While you were out, we added that people need to add their address to after they swear in. Those folks that just swore in, can we please have your addresses?
Kevin Kelly, 5904 Park Ridge Avenue, Cleveland, Ohio, 44144.
Next.
Deeds, 30050 Chagrin Boulevard, Pepper Pike, Ohio, 44124.
All right. Anyone else?
Tony Coyne, 1001 Lakeside Avenue, Cleveland, Ohio, 44113.
Thank you, Tony. Anyone else?
And Jeff Kossel, 30050 Chagrin Boulevard, Pepper Pike, Ohio.
Last call. Anyone else?
Lucas Reeve, 4540 Broaddale Road, Cleveland, Ohio, 44109.
Thank you. Again, last call. Anyone else?
Sean.
Davidson, 3912 East 166.
Wow, we got terrible with connection here.
That is, and
Are you
we're
in
just, yeah, and is this for the Pearl Road case? We're not asking everyone, just the Pearl Road case.
Right, yeah, exactly.
I believe we have
And-
Matt Moss that just logged in as well. I don't know if he got sworn in for this. Matt, I know he was having connection issues.
Matt, are you testifying on this case? Hello, Matt.
Oh, can't hear you, Matt, on the system.
All right, how about now?
Yes.
All right, I'm here.
Are you testifying on this case?
I am.
Just tell us what you represent.
My name is Matt Moss. I am with the City Planning Commission.
Thank you. I think we have them all now.
Thank you. On the history, I'm sorry, on to a legal standard, Wagner.
Unmute. Thank you, Madam Chair, members of the board. Appellant is requesting area variances from the pedestrian entrance, access driveway, maximum number of off-street parking spaces, screening, and landscaping requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code. Please note that section 34804F2B states that the board may grant a variance to increase the maximum number of parking spaces where the applicant has shown a good faith effort to first utilize district parking, on-street parking, and or secured shared use agreements with adjacent property owners, or has agreed to make its parking lot available for shared parking with neighboring businesses.
Actually, I did skip the history. Sorry about that, Larry. I'm having a case for Mondays. So go ahead, Ms. Kukla.
Thank you. The property was originally zoned general retail in 1929. In 2016, it was changed to the local retail business district. I did not get the date on the urban form overlay district. Perhaps Matt Moss could give us that date. In the records room, I found that a use for a muffler shop was established in 1975. And then I did find that there are variances on file in variance cases in calendar 10-091. A request was made to establish motor vehicle repair garage, but that case was withdrawn. In calendar 11-070, again, the appellant applied to establish motor vehicle repair, and that case was withdrawn. And then later in that same year, in calendar 11-190, a variance was granted to establish use as a motor vehicle minor repair garage. And then in the more recent history in our Acela system, in 2012, a permit was issued for alterations to change use to that minor vehicle repair. And that's all that I had, Madam Chair.
Thank you, Ms. Kukla. Maurice, can we have a summary of the variances, please?
Sure. So we have quite a few variances, and we're not used to seeing most of these because this is from the urban form overlay district, so we don't get a lot of these. We are looking at the fact that a pedestrian entrance is required on the secondary street frontage. I'm getting a lot of feedback. Let's see, who?
Yeah, if you're not speaking, please mute yourself.
Thank you. Where was I? We also have that they have more parking than what is required, so they're exceeding, they cannot exceed by 120%. The parking access drive is not permitted on the principal street frontage. There is no 3-foot landscape strip, which is required. None is provided. And those are basically the variances that we're looking at.
Thank you, Maurice. So who's going to be the spokesperson for this case?
This is Tony Coyne. I was going to walk through what's on the agenda to address those variance requests, and Jeff Deeds or Jeff Kossel may also join in.
Okay, go ahead.
So the first, and I'll summarize these, the first item regarding the pedestrian entranceway on the secondary street. This will be a bank, and banks have their own standards, particularly for safety and security. But this side would be the third entrance to the lobby of the bank. It's also in a tight location where there's a bit of a grade change, so it would be difficult to put in a doorway in that location. As you can see, it's just off the south side of the bank building, and it would likely not be easy to install it as an ADA accessible entryway. The entryway on the front of the building is compliant with the urban overlay. And of course, there's a secondary entrance to the rear of the building from the parking area, which also accommodates handicap parking. So that's the basis for that initial request. The second issue regarding parking, and again, under your code, it's a good faith effort for compliance. Where this is a little bit unique, under the code, it would only accommodate 6 parking spaces. This bank would likely have 3 or 4 employees, therefore it would leave little or no parking spaces for customers if it were formally complied with under the technical requirements of the code. In addition, and I'll talk about this in a second, there's been a request to have the property to the north have a shared parking and possible access. And the Visconsi companies that are developing the property, they've agreed to use their best efforts to do that. In fact, as you can see on the, this is the technically the code compliance site plan, though I might add. They are designing it so that future connection could take place. So that's the reason for that request. Insofar as the third request, which is the width of the entry drives, I just note that the requested curb cut, which is existing onto Pearl, is one way entering only. So the access drives onto Henninger are both going to be in and out 2 ways. And normally those are designed at 24-foot aprons. So that's just what would normally be done with a commercial building. I know code says 20, but that would be preferable, and that's why that request was being made. Again, that is more for traffic management, vehicular management when cars turn. So that was that issue. The fourth item on the agenda is the landscape strip on Henninger. So we're clear on that. The masonry wall adjacent to the bank building, Visconsi's in agreement to install that. The part that we'd like to have not masonry but shrubbery is in front of the parking spaces that are on Henninger. If we use shrubs, that should eliminate car lights if they're on, although it is a bank, but there could be other uses at night, I suppose, or when it gets dark earlier, so that we keep lights from going across the street. There is a house at the very end of the lot, but more importantly, they prefer to have it a little more open since there is an ATM. There are 2 ATMs in the back part of the parking area. And from a safety standpoint, we think that's really important. And we know just on July 2nd, there was a bank in the area that did have a robbery take place at an ATM. So the bank is very cognizant of that and would prefer that be a nice line of shrubs or boxwoods in that location. And I think, the other item we did submit, and this plan is the code compliant plan that was requested by the planning staff so that you could see what a code compliant site plan would look like. Again, you can't tell easily, but there's technically not a curb cut out onto Pearl in that location. And I will note that Jeff Jeff could contribute to this if you want to, but without that curb cut, there would be no ability really to develop this property. The parcel to the north is not yet owned, but hopefully to be owned. There isn't a current certain use for that, but we recognize that we'll have to be careful and be as compliant as possible with the overlay district, which is the reason for the cross-access easement for the parking area. So I think, and maybe if I could ask Mr. Moss, does that address the main issues that you had flagged in previous correspondence a couple weeks ago?
Yeah, Madam Chair, would you like me to speak to what Mr. Coyne just covered?
Yes, go ahead, Matt.
All right, thank you. This is Matt Moss with the Planning Commission. Just to provide some additional context, this project did go through an extensive design review process because it's located, not only is it new construction, but it's located in a designated design review district. So this general plan and the elevations, the new building, were approved by the Planning Commission. And we're working out the final details here, as you can see, as they relate to the zoning code itself. So I think I want to thank the project team and Mr. Coyne for this overview and providing this plan. I think it makes it really clear what the code is requiring and how we're working to accommodate that in this specific location. I think the issues as responded to by Mr. Coyne are comprehensive and really cover, I think, what staff's concerns are and how this project relates to the code requirements. I would say that from my perspective, the most important items are the easement for access to the north. The urban overlay does not permit curb cuts on the primary frontage when there is a secondary frontage, and the goal of that is to preserve walkability of primary streets. And the reason why we mapped this as part of the rezoning was to preserve and then continue to enhance the walkability that Old Brooklyn has, especially along Pearl Road. And I think that the curb cut through the design review process, the curb cut on Pearl, we agreed to through design review with the team as a way to, along with an access easement on the rear of the property from Henninger to the property to the north, because that property is not being developed by this developer, and if it were developed separately, they would require a curb cut, essentially another curb cut on Pearl. So we made the decision to support a curb cut on Pearl here, a single curb cut, one-way access in order to create the potential for future development to the north that wouldn't need any curb cuts on Pearl. So that seemed to be the best outcome in terms of reducing the vehicular access that's across Pearl. Because if you look at the current conditions, there are quite a few curb cuts currently. So we're trying to reduce that. So I think we're supportive of that variance. I think as long as the developer is willing and committing to work with us to make sure that however the property to the north develops, that you can see here at the lower right of this aerial image, they can have access from Henninger for vehicles if they need it as part of that development. So that's totally sufficient. I think the screening requirements and the compromise mentioned can work. I think we'll want to just verify the design of that prior to as a condition of the variance approval. I mentioned to the development team that I think a combination, so a screen wall is still preferred closest to the bank building, but along the parking, landscaping, and maybe like a aluminum rail fence, something small, again, nothing that would obstruct views, but generally the code requires it to be 3.5 feet tall. So something to that scale, I think, would be appropriate and is an acceptable compromise. And then the last thing I would say that I think is on my list is the secondary entrance. Because you can see how the bank is laid out, they have an entrance on Pearl and they have entrance to the rear to the parking lot for ADA access. I think a good alternative would be, instead of providing another doorway on that frontage, would be to just provide a pathway that if it can be graded appropriately from that rear entrance to the sidewalk. So trimming that screen wall just a little bit, providing a pedestrian path, I think would meet the intent of what the code is trying to accomplish here without requiring a new door on that frontage. So those would be my suggestions and conditions for approval. I think the project team's done a great job working with the city in terms of making this a successful project. The only other thing I would note is regarding them building more parking than the code is required. again, the reason why that's in the urban form overlay is to try to reduce the amount of land that's being used for car storage. I think that in a lot of cases, especially with projects like this, where parking is needed than perhaps what the code is allowing, if the development team is willing to work, because banks have traditional hours, they work and operate during the day. If there are other land uses and other properties along Pearl that we've identified and see potential for development, and along with the development corporation, that may not be able to provide either a code compliant amount of parking or even enough parking for their operations, which are really two different things. I think if the development team, I've mentioned this to them, if they're willing, and if the bank is willing to explore sharing parking in their off hours when they're closed or off peak hours, I think that's a great example of how we can continue to work together to improve Pearl Road and make it the most walkable, pedestrian friendly street we can. Thank you.
Thank you, Matt. Mr. Coyne, you heard what Matt said. Are you all amenable to those things?
Yeah, I think we can for sure make sure the shrubs are 3.5 feet high. The one question I did have about the walkway from Henninger, would that be to the rear door on the west side of the building? Is that what Mr. Moss meant?
You can answer, Matt.
Yes, that's what I was mentioning as
Okay.
just a compromise. So if you're walking from Henninger, if you're otherwise accessing this from the rear, you don't need to walk through the parking. Just
Okay.
walk right off the sidewalk.
Okay.
I think that's the solution to having a doorway specifically facing, like specifically on that southern building wall.
Mhm. Okay. Just I'll make sure, Mr. Castle, would that be okay? So we have to have the shrubs would have to be 3.5 feet, and you would probably, well, you wouldn't put that screen wall as long because it would come up, you'd have a walkway from Henninger to that walkway to the rear entrance.
Oh, I'm in agreement with regard to the 3.5 foot shrubs at the west end. The unfortunate thing is the sidewalk along Henninger is almost 2 feet higher than the finished floor of the building. So you can't really have a direct connection there. It would be too steep. So we think that the front entrance, being at the very close to the intersection, we could match the grade, and any pedestrians on Henninger could actually enter the building very easily using that front door, or they could walk through the parking lot in the rear. But doing a direct connection just creates all kind of safety and liability issues.
So I'm clear. You mean a walkway to the walkway to the rear door? That's a 2-foot grade change?
Just under 2 feet, yes.
Oh, okay. Matt, what are your thoughts?
I just want to clarify that I'm talking about not to the into the building, but there's that
Right.
path behind the building. I guess I still don't understand why a sidewalk, like a concrete
Yeah.
walkway not to that door, but to that already planned in path isn't feasible.
Yeah, I want to make sure we're clear on that too. Jeff, he wasn't saying a new entryway to the side of the building. It was just okay.
Correct,
So-
I follow. Yeah, unfortunately that building's only 5 feet away, and coming up almost 2 feet and 5 feet is way too steep. So, I mean, if they were at grade, I'd be all for it. But unfortunately, the existing Henninger grade's much higher than our finished floor, which we can't raise because we have to connect to the sidewalk on Pearl. So it's not that we could adjust our design.
Would a step make sense?
Liability concerns again, but we feel that the front entrance addresses the pedestrian friendly aspect of it.
Okay.
And, I know this isn't a legal reason, but you'd end up with kids on skateboards trying to go down those steps or ramp if it were that, and hitting our customers entering and exiting the building. So I understand Matt's desire for the connectability there, but I'm not sure it can work safely given all the other conditions.
Matt?
I mean, I guess like it's not necessarily my preference that I'm advocating for here. It's the intent of the code. And
Right.
I mean, I guess it's up to the board to decide if concerns about uses that might be incompatible with the bank, like if there are people on skateboards doing whatever, or anything else speculative. I think it's up for you all to decide whether that's not appropriate. I don't think it doesn't need to be ADA compliant, since they have ADA compliance through the parking lot. So there could be a step there if there are grade issues. It's not something that, it doesn't seem to me like it's an infeasible accommodation, but that's my opinion.
Okay.
Hey, Tony, this is Jeff Deeds speaking.
Yes.
Could Jeff Kossel, this question to you, could we install a sidewalk along that curb line that comes in? So it'd be like an L-shaped sidewalk?
Yes, we could. It would still be too steep to be ADA compliant, but it would be preferred versus a step.
Okay, I believe Matt did, it's a lot of feedback. Whoever is not muted, mute please. Okay, I believe Matt did say that portion did not need to be ADA, so I think we might be working on an agreement here. Is there anyone else in the project team that needs to speak?
I think we're good with all of the our explanation on the practical difficulties related to the site issues, and obviously I think we explained the parking, and I think we're in pretty much agreement, and as Mr. Moss said too, this went through some design review and was pretty well received. So
Yeah, I just want to add briefly that I think if they wanted to route this like a pathway along the parking lot entrance, I just think the goal is to have an entrance from the street that is pedestrian dedicated, that's separate from parking lot. So if there's if that's the preferred route that alleviates the development team's concerns, that's also acceptable from my perspective.
That if we can go steeper than ADA requirements, then we could accommodate that.
Yeah, I think that as long as that's not an issue for building and housing, I'm not an expert on the ADA requirements, but I think if you're already providing it in 2 locations, it should be fine.
would it be okay to request approval of these variances and the exceptions under the urban form overlay? And on that particular issue, would the board be able to refer that to staff and the applicant to work out? It's such a small issue in some respects, but we want to make sure it's done right. And if it looked like it wouldn't be particularly feasible because of the grade change, that we would, not have to do it. But if it was doable, then we would agree to it. Would that be possible with staff or no?
Let's hold that question for 1 second. I want to make sure that I hear from everyone from this case. So is anyone else that signed up that needs to speak outside of the councilman?
Yes, good morning. This is Lucas Reeve from the Old Brooklyn Community Development Corporation. Appreciate everyone's time this morning in reviewing this case.
Good morning.
Good morning. I don't want to belabor any of the additional points. The only point that I did want to make is that one of the things that we feel is critical here is the easement to the property on the north, as Matt Moss highlighted in his statements. I think granting the variance for the apron and the access to Pearl Road is certainly important to development on the southern site here with the bank. But the property to the north has for some time now been a troubled property within Old Brooklyn as it relates to its current condition and its placement, directly across the street from our brand new 25-acre park and a pocket park, both managed by Metro Parks. It's really a key property within Old Brooklyn. And so in order to help facilitate further development on that northern property, that easement through the southern lot is tremendously important to that end. And so I think as part of approvals this morning, it would be good to ensure that the approval of these variances is based on the condition that the easement is granted to that northern lot, so that whether it's developed by the applicant group or a future group, that development is possible in the future.
Thank you, Lucas. Lori, is that something the board can add to our conditions or not?
I'm sorry, I heard all that, but I'm not really sure what you're talking about. The property to the north is owned by another party?
It is not. It is owned currently by the same party.
And your request and your feeling is there needs to be an easement for what purpose?
So that the future development to the north is able to take place under the urban form overlay, which wouldn't require an additional curb cut and apron access off of Pearl Road.
I mean, theoretically, the board can require an easement if it's relevant to the conditions of the variance. I don't think I understand this enough to state if that's the case in this particular case, but.
Yeah, I was kind of struggling with that too. That's why I asked you, but okay.
You're asking the owner to give an easement so they can develop their property to the north. I mean, wouldn't they do that automatically?
Great.
If I could just note, we'll use our best faith efforts to agree to that. As a formal condition, it's a little bit tricky because Visconsi doesn't own the property yet, and there's also not an identifiable user. But Mr. Reeves' comments are well taken. We understand that it's a constrained parcel. Something like that probably would be important if it's going to be developed, depending on how it's developed. They've actually talked to some residential developers, but they're not sure that it's a developable site for residential. So
I think under the circumstances here, that would not be an appropriate condition for the board to put in. It will be part of the record, however, that it was discussed.
Great.
Madam
Thank you,
Chair.
Lori.
Madam Chair, we have Matt Moss and Elizabeth Kukla with their hands raised.
Okay. Go ahead. We'll hear from Liz since we heard from Matt already.
Hi, so regarding Lori's comment about not really understanding what they wanted to do, my understanding is that the future development, that the easement would allow for the future development to get rid of the current curb cut. So it is restricting the future development of that property to the north, while giving them the main access, or the only access would be from Henninger. So I guess to the appellant, is that, or even Matt Moss or Lucas Reed, is that the understanding that the future development would be restricted by this this easement agreement?
Not all at once.
Matt, we can't hear you.
Oh, sorry, I was muted. Madam Chair, I think I can answer that question.
Great. Go ahead.
So the way this property to the south is currently laid out, the property to the north that you see that has that drive-through restaurant structure on it is right now is actually L-shaped. It is a parcel that fronts Pearl and also fronts Henninger. As a part of this development, the portion of the property that fronts Henninger is being split and consolidated with parcels to the south that constitute the current auto garage, which will be torn down and redeveloped as this bank. That whole process splits off the northern parcel from Henninger. So under our code, in order, the property to the north, if it were redeveloped once these properties are split and reconsolidated, would be permitted to have a curb cut on Pearl. But what we've done in partnership with the councilman and the CDC through the rezoning is one of the things we're trying to do is to limit or eliminate as many curb cuts on Pearl as possible. And that's because we want Pearl, especially this section of Pearl, near Brighton Park, near the zoo, to be as pedestrian friendly as possible. So that's the reason why we've been asking the developer for this easement. In the beginning of this project, they were considering, it was my understanding that they were considering developing it. It's just, there's not enough information. That's not something that's moving forward, my understanding right now, which is fine. But that's why we've made this request, because if the goal is to consolidate this land and create a parcel to the north that only has vehicular access available to it from Pearl without an easement, that's the origin of that request. And it's not that it would be the only access from Pearl Road or from Henninger. It would be, we want the vehicular access to be from Henninger and the pedestrian access to be from Pearl.
Great, thank you. I think we understand that part. We're just kind of struggling with if we can make that a condition for future development in our, if we approve this case today. So we'll put that in the parking lot for right now, and then we'll hear from the councilman.
Thank you very much. I appreciate all of the thought that's gone into this. I appreciate our attempts to, to reach the, a compromise or something that will get this project done, comport with the zoning code, the zoning overlay. But my thought is, let's just figure this out. Let's get this done. This is a critical project for the neighborhood. Somebody described the site as challenged. That's an understatement. The site is terrible. And it's right by the zoo. It's an embarrassment. And we need to put a nice, vibrant, new looking building here. And we have a developer with a reputation that we can rely on to follow through and do what's right. We have a plan that fits the need of a neighborhood in terms of having a retail bank. So, I appreciate what I was doing, but bottom line is, however we need to figure this out, let's figure this out, because this is critical that this happen. It's critical that we allow construction to begin as soon as possible. Thank you.
Thank you, Councilman. So I believe that means he's approving this case. Board members, any questions, comments, chime in here?
I have no questions, Madam Chair.
The only question or concern I have is whether it's in our legal purview to put the easement in on a piece of property that isn't owned by the developer yet.
Right, that's the only sticking point there. I agree.
Once again, I think that's an issue that would be most appropriately determined at the time the second property is developed as part of any approval process then. I do not think it would be, and given that they're not in the same ownership, I do not think it would be appropriate for the board at this time to require an easement be given to the property in the north that's owned by another party. It just doesn't relate to this case and the variances before this board.
Thank you, Lori. So with that being said, if there's no other questions, I'll entertain a motion.
Madam Chair, based on the testimony and the, I think, very detailed response to the various questions regarding the development project, I would move that we would support those variances, noting that there is an easement that has been brought up in terms of connecting the two properties in the future, something that we are unable to do due to the current ownership. However, to be noted in this approval process so that it becomes still an active ingredient, if you will, on the development of the parcels.
Have a second?
Second.
Thank you. Call the roll, Ms. Kukla.
Madam Chair, I'm not sure if I heard Mr. Donovan mention the new landscaping, was it 3.5 feet high shrubs or wall? Is that something we want to put into the resolution? And also, are we going to wait for a revised plan showing that?
I believe we should put the shrub height in there and request a new plan before we can ratify.
Yeah, any changes to the original plan that have been detailed through this interaction, if you will, should be reflected in a new plan so that we can spell out those variances, a la the shrub height, et cetera, that you mentioned now.
Thank you. We had a motion and a second.
Second.
All righty. Kukla.
Thank you, Madam Chair. The other issue is are we going to make the access from Henninger to that pedestrian entrance an issue in the resolution as well? We're going to make that a requirement.
I believe they agreed to the steeper step although it's not ADA, but that will be reviewed by Building and Housing. So if something comes up, at that point, they'll have to work with Building and Housing on that.
So we would add part of, in the resolution that pedestrian access will be made from Henninger, regardless of how the configuration works out. Does that sound all right?
Correct.
Okay. Ms. Barnes?
Can I add, this is Jeff Dietz. Can I add something just real quickly about that sidewalk? I thought
Mr. Dees, we're in a motion and we're getting votes right now, so please hold.
sorry.
Ms. Barnes, I did not hear you.
Barnes, yes.
Ms. Faith?
Yes.
Mr. Donovan?
Yes.
Ms. Britt?
Yes.
Calendar 21-114 is granted conditionally. Did you want to take additional comments, Madam Chair?
Yes, if Mr. Dees has something else to say.
Yeah, I just
Quickly.
Yeah, first of all, thank you very much, and thanks for taking this little extra time for me. I thought what we had agreed to on the sidewalk, I just wanted to make certain that everyone was clear, was to kind of follow that curb line that goes in, as long as it's acceptable from an ADA perspective. And if it does not have to be ADA acceptable, then that's okay.
Yes, that's why once you put it on the plan and submit it to Building and Housing, you'll find out if that needs to be ADA back there or not.
Okay, all right, thank you.
Thank you.
So again, this case 21-114 is granted conditionally pending that revised drawing showing the conditions that were stated. Once we receive those revised drawings, we will ratify the case and send you a letter.
Thank you.
Okay, yeah, we'll start back at the beginning.
Okay, excellent. Moving back to calendar number 21-109 at 3912 East 155th Street. Rita and Jesse Davidson, owners, propose to establish use as a residential facility for 6 occupants in an A1 one-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record.
Thank you. Mr. Donovan?
Everyone who is going to give testimony to this case, kindly raise your right hand. I will make a statement. I'm looking for a response of I do with your name and address. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do. Rita Davidson, 3912 East 155th Street, Cleveland, Ohio, 44128.
Thank you. Next, anyone else? No one? Last call. It appears we have one witness. Okay.
Oh, okay. Moving on. We take the history.
Thank you, Madam Chair. There's been no change in the zoning since 1929. In the records room, I found that in 1935, a permit was issued to erect a single-family dwelling. 1978, permit was issued to apply aluminum siding. There are no variances on file in our office, and in the Acela system, we found nothing of note. Back to you, Madam Chair.
Thank you, Ms. Goga. We'll have the legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting a use variance. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economically feasible use of the property without the variance, would deprive the appellant of substantial property rights, and that granting the variance not be contrary to the purpose and intent of the zoning code.
Thank you. Maurice, a quick summary, please.
Sure. On this one, we're looking at a proposed residential facility. They are looking for 6 individuals, and the zoning category, the one family district, only allows up to 5, and they are also within 1,000 feet of another residential facility.
Thank you. Ms. Davidson, go ahead and present your case.
Yes, first off, I want to thank you all for taking the time out to speak with me. But I did update one of the items on my application, which was the residence. I changed it from 6 to the number 5. And I do know that there are residence homes around me within 1,000 feet. And from what I've come to realize and find out was that it was only supposed to be 1 facility in the area, period, and 2 was allowed. So I don't think that the home that I'm seeking to open up for these people will be an issue, because it will be ran properly. It will create stability, structure, and also employment, as long as it's ran properly. So that's just my case. The owner of the property, Jesse Davidson, which is my husband, he won't have anything to do with this. I have a love for people, so this goes deep down in my history of growing up in foster care, and even a mom having foster children. So I just have a love to help people. So I don't think it'll be a problem with another home being within 1,000 feet.
Okay, I understand.
Madam Chair, this
Yes.
is Lori Wagner.
Okay.
If the applicant is only asking for permission to have 5 people, then the legal standard is totally different.
I was just going to ask you.
Yes,
Okay.
exactly. The standard then would just be for the area variance to allow a home within 1,000 feet of actually what looks like 2 other homes.
Yes.
And the standard there is to obtain that the appellant must prove that the denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code. And I would ask that any motion the board makes, whether it's to grant or deny or whatever, would make it clear that the applicant's request is for a 5-person home, not a 6-person home.
Thank you, Ms. Wagner. Yeah, and I was also going to tell the appellant, I know that you probably feel like that it's not a situation to have others in 1,000 feet, but it is the law of the city. So that's why you had to come here, because you're in violation trying to put this home here with 2 other homes in 1,000 feet. So I'm sure my board has some questions for you. So if anyone wants to chime in. Hello?
Madam Chair, sorry for the delay in unmuting myself.
Oh, no problem.
Typically we ask appellants for these types of homes, how they're going to acquire the residence, the gender of the residents, if there's going to be staff on hand, if there's going to be medication dispensed, if there's going to be someone on staff 24 hours. Those are the typical questions we ask in these types of residential housing situations.
Correct. Ms. Davidson, you heard my board member ask certain questions. Yeah, we need to know, like, who want to put in this house, what's the gender, hours of operation, staffing. Have you talked to your community? Have you talked to your neighbors, the council person, that kind of stuff. So I'm not even sure if you know that were required to do all that before you came here.
Well, I did speak with my neighbors about it. And it is going to be staff in the home, and the home hours are going to be from 6 a.m. to 11 p.m. And also, I didn't talk to the councilman about it, but it is in the works. I do know to do that, but it hasn't been anything held where I can go to a meeting and speak with my councilman, but I have spoken with the neighbors.
Ms. Kukla, did we
And
get
I
any
think,
did we get any kind of correspondence from neighbors or the councilman at all on this?
No, I haven't received anything from either.
Yeah. Okay. Sorry, Ms. Davidson, go ahead.
Madam Chair, looks like Lori's got her hand raised. Ms. Wagner?
Ms. Wagner.
Yes, could the appellant clarify, you said the hours are 6 to 11. Is this not a residential home where people will be living?
oh, people will
24/7?
be living there. It's a residential home.
And you will have staff there?
Yes, it will
I
be
believe that was
staff
the
there.
staffing hours. Yeah, I could be wrong. Are those the staffing hours, the 6 a.m.?
Yes, those are the staffing hours, 6 a.m. to 11 p.m.
Madam Chair, it appears to me that we need some due diligence on this case, as we always ask for. I think Alana outlined the information we need, the actions we need to be taken. And I think chief among those is obviously the engagement of the city councilman.
Okay.
So Mr. Donovan, are you asking for a postponement here?
I'm suggesting that we usually get a postponement when we don't have those answers and actions, and therefore, in this case, we would be justified again to ask for a post, or have the appellant ask for a postponement so she could address those things.
Yeah, Ms. Davidson, so what my board member is saying is normally we get a lot of these houses that come to the board, and we want to make sure that the community is aware of them, and has, some input on what's going on, as well as how you're going to run this house, so we need to see some kind of, plan on how you plan on running the house, staffing hours, those kind of things, so we can make a decision. So I don't know if anyone told you that before you had to come here today, but that's the kind of information we need before we can make a decision. You understand that?
I understand, and I wasn't told that, so I can definitely get these things.
Wonderful. And try to talk to the councilman, so you can, engage him, and he'll help you engage the community. So is 30 days, you think 30 days is enough time for you?
Yeah, I'll be due diligent on this case and getting things done properly. Yeah.
Wonderful. So you need to ask us for a postponement officially, so it'll be on the record, and then Ms. Kukla can give us a new date. Ms. Davidson, ask us for a postponement.
Oh, excuse me, my phone. May I have a
No problem.
postponement, please, for this case?
No problem. The appellant says 30 days is enough time for her. Ms. Kukla, we have.
So, Madam Chair, due to the holiday and us not having a quorum that first week in September, we would have to give it the date of September 13th.
Okay, sounds good. Are you okay with that, Ms. Davidson?
I will be, yes.
Okay. All right, so make sure you do all, get all that together first, and then come back, and then you can present all the information, and we can make an informed ruling. All right.
Question?
Sure.
I just want to make sure I go over things and I have everything together. So I need to get with my city councilman, which I knew that I haven't did that yet, but I will. I got with the neighbors. You guys need staffing, how it's going to be ran. In 30 days, I'll come back with a plan for you all, correct?
Correct.
But it's not in that order yet for the shirts.
Oh,
Madam
yes.
Chair, I would also recommend that Ms. Kukla could forward Marka Fields, the neighborhood planner.
Yep,
She
I was
might
just
also
about to
be
say
able
that.
to assist Ms. Davidson with contacting the councilman.
And if I owe you any money on that, let me know.
I think Councilman Pulisic needs to get muted here, but,
He's ordering a
Right.
shirt.
And, what? But the-
okay, Ms. Davidson, you got all that, and if you have any, questions, Ms. Cooper will email you Ms. Marcus Fields' information, and she can help
Okay.
you, put that stuff together.
Fine, Billy.
Thank you all.
Thank you.
Okay.
Thank you.
Paid for the white skis. So,
So, Madam Chair, would you like to go to the case with Councilman
Councilman-
Polensek?
Yes, thank you.
All right, excellent. So we have, we're going to move forward to case number 21093. So that's calendar number 21093 at 16115 Waterloo Road. The McPhillips Way owner proposes to erect an 80 feet tall automatic changeable copy digital pole sign in a C2 local retail business zoning district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record. We will note that the first postponement was made at the request of the city to allow for an update to the notice of nonconformance and re-advertisement.
Thank you, Ms. Faith. Mr. Donovan?
Yes, well, all parties that are going to give testimony to this case, kindly raise your right hand. I'm going to read a statement. The response I'm looking for is I do with your name and address. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do.
Address.
I do. 16115 Waterloo Road.
No, it's your address. You live there?
Oh, okay. 30120 Ridge Road, Wickliffe, Ohio.
Okay, anyone else?
Tom Phillips, 30120 Ridge Road. I do, Wickliffe, Ohio, with John, my son.
All right, anyone else?
Yeah, my name's Tom Yankovich. I'm with Ellett Sign Company, 3041 East Waterloo Road, Akron, Ohio, 44312.
Councilman Pulisic, Ward 8.
Thank you, Mike. Anyone else? Last call. Cheers, we have them all.
Thank you, Mr. Donovan. History, Ms. Cooper?
Madam Chair, we had extensive testimony at the last hearing.
I couldn't remember if we had that or not. Okay. Yes, we can skip that. Just go to the legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting a use variance and area variances from the sign regulations of the zoning code. In addition, appellant is appealing the administrative decision of the Planning Commission to deny approval for this sign. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship, particular to the property, such as there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code. With respect to the Planning Commission decision, the standard of review to be applied is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
Thank you, Ms. Wagner. Who's the spokesperson for the case?
I can speak.
And you are?
I'm Sean McPhillips.
Sean, thank you. Okay, go ahead, Sean.
Hello, thank you for everyone for your time today. So to summarize also what we talked about at the last meeting, originally we had a sign and it had access to the highway, and it helped generate a lot of revenue because a lot of cars go past the highway. they built the wall, and that substantially decreased our residential impact. And we learned with the pandemic, you know, with everyone going in their homes, residential people are a great source of revenue, and this sign, we hope to. Our original plan was okay. It can't be seen by the wall, so therefore the best solution is to make it higher so it can be. So we worked closely with Tom Yankovich and design and our community. We worked very closely with them to design a sign that was very friendly. It dims at night to like the intensity of a candle. It's angled towards the highway. In addition, this property is already pretty close to the highway now. Just in fact, the only thing that's between it is like the road and maybe and the one photographer shop that's closest to it, the Colossal Photographer Shop. He's aware of the sign project and its design, and he even signed a piece of paper as I discussed the literature with him. So we worked very closely with this community to make it the best sign possible and to help us with this situation we're in. I know there's several variances, and I feel like they've all been addressed by working with our community and making it a very practical and efficient sign of just what it's supposed to do. I do know there are other businesses that have been affected, and one of the examples I like to cite is the Sim sign, which the car ownership actually had the wall taken down. And I know, yes, that's technically in Euclid, but the point was just to illustrate this is not a unique problem to us, and communities there have made a solution to them too. And we're not asking to take the wall down. We know that helps with the sound to some degree. It's not perfect, but we feel like we want to keep what's there and just make what ours is better, and not complain, but to find a solution that works for us, and you know, everyone is happy and wins.
Thank you. Is there someone else from this case that got sworn in that would like to speak?
Yeah, I'm the owner, the old man. We used to have a sheet metal shop, and we had kept our, 4 people busy all the time, and we had to let those people go because the residential sales are down. So yeah, we've been affected on that. And, if that sign would come up, then we could hire people, and it would be best for everyone, the community. So yeah, that would help us.
Thank you. Everyone's talking about the wall. I believe in testimony last time we determined that this wall had been up for some time though. So it's not like the wall just popped up like a couple of months ago.
About 14 years, yes.
Yes. So I just want to make sure that's on record here. Is there anyone else that was sworn in that would like to speak before I go to the councilman?
We do have the neighborhood planner, Sharonda Watley, online as well.
Sharonda.
Good morning.
Good morning.
Everybody. Hi, I don't have very much more to add. You all had seen this a few weeks ago. I am here to confirm the decision and the comments from the Northeast Design Review Committee as well as the Planning Commission. This proposal was denied at both reviews a couple of months ago. And so a lot of the comment was based on the extreme nature of the variances that were requested. Luckily, we are now recording all of our Planning Commission meetings, so I was able to kind of go back and refresh myself on some of that commentary from Freddie Collier, director, as well as from a number of the commission members. And so, again, this is a really unique sort of ask for this particular area, and I honestly appreciate you all's time here today. So with that, I will hand it over to Councilman Pulisic.
Before we go to the councilman, Sharonda, just a quick question. Can you just give just an overview summary of what the comments were in Planning Commission as well as Design Review, since one of the variances here is to, appeal that decision?
Right. There was a lot of conversation. I'll start with design review. There was a lot of conversation about the appropriateness of this particular sign. There was a lot of conversation about understanding that they have been a mainstay in this community for many years, many years. There was a lot of conversation about how this sign and the design of it would impact the particular neighborhood. I will add that the design review committee has not approved a new pole sign since I have staffed that particular design review committee. So that would be definitely a break from precedent to approve a new pole sign. And so I think that they were really interested in really understanding the need here. And then also what could potentially be done as an alternative for signage or for drawing attention to this particular business. At the Planning Commission level, a lot of the comments, again, were based on the extreme nature of the variances that were being required. And then also they wanted to more so focus on the design aspects and leave the code issues to this able body. And then also whether or not the determination for a freeway sign, they wanted to leave that determination to ODOT and others. So they really very much so focused on the design and not being comfortable with allowing such an extreme amount of variances.
Thank you, Sharonda. Councilman, would you like to chime in?
Can you hear me?
Yes.
Can you hear me?
Yep.
Okay. I had the opportunity to meet with Sean McPhillips, and I've talked to other merchants and property owners in the area, including not only commercial properties, but residential as well. I think we've all come to the realization that the appellant is asking for a sign that is critical to their business operation in light of the fact that the noise walls did impact not only them, but other businesses in the community. They're at the very end of the arts and entertainment district, so it's not something that I believe will have an adverse effect on the rest of the businesses and operators down the street. And the way they have the sign, proposed sign, on an angle, proposed to be on an angle, again, would not impact the adjacent residential community to the east or to the north. So based on my review of the site, and I walked the site, review and my interaction with the adjacent property owners and neighbors, I am in support of the Board of Zoning Appeals granting the variance to McPhillips. I think it's important for their business operation, and I'm in support of it.
Thank you, Councilman. Board members?
We do have Elizabeth Kukla with her hand raised.
Oh, okay. Go ahead, Liz.
Thank you, Madam Chair. Just to remind the board members that this is an electronically changeable sign. And there was testimony at the last hearing that there would be different messages per season and other things such as sales and such. So again, this is just a reminder that this is a digital sign that they're asking for as well.
Thank you, Ms. Kukla. Board members?
Would the appellant, if the sign was erected, would it include advertising or messages from other industries, businesses, etc., beyond the appellant's business?
No, it would not. That would make it into the billboard category, though. I think this is a good and practical solution considering the variances. Maybe when the first proposed building a $1 million wall, that seemed like an extreme solution, but sometimes it's not extreme. It's just the best fit. So we've explored many options, and we feel like this is the best fit that helps that takes into account everyone's concerns and makes everyone happy.
Okay.
So is there an argument that the city planning or design review was arbitrary or capricious in their deliberation?
I believe one of these is an appeal of the decision from city planning, correct?
That's correct.
Right, and our standard was the body arbitrary or capricious, or was there, I guess, resolution not supported by the facts? And I mean, I think
Madam-
that's the first hurdle we have to cross before we then say, okay, let's now listen to see about the variance. Lori, am I right on that, or?
That would be correct.
Madam Chair, this is Liz. I
Go
did
ahead, Liz.
receive an email appeal statement late last night. And so we weren't able to get it into the PowerPoint. I did send it to Maurice this morning. I'm not sure if he was able to amend it. So perhaps the appellant could read it. I could read it as well if the appellant didn't want to. But yeah, we would like the appellant to speak to his statement regarding that appeal.
Yeah, of course. I believe from my understanding of the Board of Zoning Appeal Commission, they were simply aware of the variances, and because there were variances, they thought it was more appropriate that the Board of Zoning Appeals made a decision based on whether to make to allow the sign to go forward. So I can pull up my statement, but it's essentially along those lines, and I agree that would be appropriate as the governing body. You guys, I feel like, have the most information and input and expertise to make that decision.
Madam Chair, I did listen to the recording this morning to verify what happened, and I will state that Lillian Curry, one of the commissioners, made comments that she thought that she asked about the age of the wall and the fact that it was 14, that's been there for 14 years, was something to be considered, that this is not a new situation. And she also made the comment that this is such an extreme variance that they felt that they were not comfortable granting such an extreme variance, not just a variance, but that it was such an extreme variance. Commissioner August Fluker also agreed with Lillian Curry and thought that there must be some other better solution than this. And he also agreed that because of the extreme variances, he was not comfortable passing this and wanted the Board of Zoning Appeals to look at it. Director Collier also weighed in and had the same opinion. So it's, I don't think they were arbitrary or capricious or not supported by the preponderance of the evidence. They felt that it was too extreme for them to pass.
Thank you. Mr. Donovan, does that answer your question there?
I think it does, yeah. Although there seems to be still a little bit of a mixed message there, in that somehow or another they did vote. They did vote to deny, and so coming to us to say that somebody wants to challenge that decision is well within our realm. However, it's based upon, again, is it arbitrary? Is it capricious? Is it unsubstantiated by the facts? I don't hear that there. I think they made their deliberation and made their decision, knowing that it could be brought to us, but also knowing that they did make a decision there and it wasn't arbitrary or capricious, at least in my mind.
Thank you, Mr. Donovan. Any other board member want to weigh in on that?
Madam Chair, I would say that I would agree with Mr. Donovan's assessment of what the Planning Commission voted on.
Thank you. I see Ms. Kugel has her hand raised. Is that a previous hand raise or?
That was a previous, sorry.
Okay, no problem. Okay, well, we have the summary from what happened at Planning Commission. So I guess I'm gonna move to my board for a motion unless the appellant has anything else they would like to say.
Yeah, I would like to say something. Again, like Mr. Plutzik said, we are at the end. I think if you guys are seeing what we're seeing, the only thing between the sign and us is the street and the wall. And again, I've been doing this since I'm 12. I've been doing this for 45 years. And again, we lost all our residential sales, and the sign we have now is, it's up a little, it was up so people could see it on the freeway. This sign, yeah, it's above the variance. It's a little bit higher, but it will bring us back to where we originally had. And if we can do that, we'll be hiring more people, and it's, we're going to be paying more taxes on more sales. And, we have lost that in the last 14 years and things have not been that good. Now we're trying to, get back to where we were originally. You see the red sign that's there. Yeah, we're raising it up just above the wall so we can do what, but we're not in anyone's view. We're again at the end of the art district. The only thing between us is the road and the wall, and all our neighbors are okay with that. And we'll be hiring more people to do some residential sales, which will help pay taxes and so forth. So, and I think the Planning Commission knew that you guys were higher up on the list and that you guys should make the final decision. So we're just asking you to help us so we can, employ some more people and do well for everyone. That's all we're asking.
Okay, thank you. Board, any other questions or comments? If not, I'll entertain a motion.
Ms. Kukla has her hand raised again.
Thank you. This time it's not
Okay, it's a real hand raise. Okay.
So there's some language in the sign code that states that businesses are allowed to have a sign directed towards the freeway if they are a certain distance from the on or I think it's the on or off ramp or interchange. So Mr. Riccardi, I believe, is on the line. If you could speak to that. I just thought the board should know that there are certain businesses are allowed to have signs that are directed towards the freeway, but you have to have a certain distance from an exit.
And be in a certain zoning district.
Mr. Riccardi? I don't know if he's on here, Liz.
Yes, I am.
Oh, okay.
That is true. The code allows for certain, it's known as a freeway interchange sign, which can be quite high, but this does not qualify for it. I think the distance is 600 feet or 500 feet. But the actual placement of this sign is not close enough to the actual highway exit or entrance ramp to qualify under the zoning code.
Thank you, Mr. Riccardi.
But it could lay a case for a variation based on that rather than the current evidence. I mean, the appellant could make a case that although they may not meet the strict application of the language, they do in terms of just the nature of it, at least in my mind. Which could lead us to say that we don't find the Planning Commission arbitrary or capricious, but then we would look at a variance based on that exception. Does that make any sense to anybody? Or?
Well, yeah, I was going to say, I think you just laid that out. So you want to make a motion on the Planning Commission issue first, and then we'll move to the actual variances.
Okay, Madam Chair, given the testimony, I do not think that the Planning Commission or Design Review was arbitrary or capricious in its deliberation and findings, and would vote that we would find them that way.
Have a second?
Okay.
Second. I would second.
Call the roll, please, Ms. Kukla.
Ms. Barnes? Ms. Barnes, I can hear you. Okay, we'll go on to Ms. Faith.
Yes.
Yeah. Mr. Donovan.
Yes.
Yeah. Ms. Britt.
Yes. Yeah.
So this is the separation between the administrative appeal, and now you guys are going to consider the variance request, right?
Correct. Correct. So can I have a motion for the actual variances for the sign, please?
Madam Chair, based on the testimony provided that there is an exception to the rule based on freeway exits and freeway access, although this does not indeed meet that code language, I believe it sets up a legitimate request by the appellant to provide this sign. I would make a motion that we would, under that kind of circumstance, that we would grant the variance to allow the sign with the understanding that the sign will be used only for messaging on the local business itself, will not include any other outside messages or advertising, etc. And that the sign itself, would the business unfortunately go out of business, the sign would be removed.
Okay, is there a second?
I'll second that.
We do have Mr. Riccardi with his hand raised.
Go ahead, Mr. Riccardi.
I'm not exactly sure what you're doing procedurally, but if you're ruling that the city planning was not arbitrary and capricious and that their decision still holds, then it's not really relevant to the rest of the, as if this was a freeway interchange sign. It's just not close enough to be considered, because even in either case, the city planning commission approval is required because it's in a city planning district, and their decision has to be overruled in order for this sign to go up. Thank you.
Ms. Wagner, is that the case? I was under the understanding that we were splitting it out, but if that's the case and we have found that
that would not be the way I would interpret the code. I think Mr. Riccardi has a stronger understanding of the code than I do, but based on other issues, for instance, that where the planning commission decision is reviewed, I think the board has the power to separately grant variances if it chooses. Even if they say the planning commission wasn't arbitrary and capricious, they could still grant variances for this sign. But once again, that's ultimately building and housing is going to have to make that determination.
And we have Mr. Riccardi again with his hand raised.
Mr. Riccardi?
Well, I just don't see how it could be interpreted any differently. City planning approval is required for this sign. City planning denied it, and it seems as if you're upholding the city planning commission decision. So maybe I don't understand, but I don't see how the sign can go up when their approval is required. It's been denied, it's been appealed, and their decision has been upheld.
Was the issue of the freeway ramp discussed or presented during the request for the approval by city planning?
The only thing that was discussed about a freeway sign is the fact that the Rick Case, or I think they've changed the dealership name, was in fact a freeway interchange sign, and even that sign is only 40 feet tall, and this sign is going to be 80 feet tall. And that is a completely legal sign. It's in an industrial district. It's within the distance of an entrance ramp. That is the only thing that was discussed about that. This case is, they're not even asking for a freeway ramp sign. Building and Housing did not adjudicate it that way.
Well, yeah, because from our understanding from Mr. Riccardi is that doesn't qualify for that type of review because it's not close to a ramp or interchange. So the question here is, if we have upheld the city planning ruling, is there a avenue for us to then forward to grant these variances. But if Mr. Riccardi is saying that if we do grant these variances, and then it still has to go to city planning and they say no, then they don't get them. So I felt like city planning commission kind of kicked this to us. So so we're kind of like in a quandary here. So Ms. Wagner, should we keep it separate, or just now that we have upheld the city planning's ruling that it's pretty much over?
I don't know what to say. The sign code is very confusing, and I don't know what the standards that City Planning Commission was using to review the sign. I would think those standards were more geared towards the appearance of the sign rather than the size and the height. And I think it would be appropriate for the board to make a ruling on those variances. If the ruling is to allow the variances, then this is something staff is going to have to figure out later whether a permit can be issued. I don't know how we can decide it here and now. I don't have enough information. But since we've had the hearing and they've been here twice, it probably would be best if the board ruled on the variances.
We have Mr. Riccardi and Sharonda Watley with their hands raised.
Okay, we'll go to Sharonda first and then Mr. Riccardi.
I just wanted to confirm very quickly that the Planning Commission did see a very full, robust presentation on the issues from zoning staff. Specifically, Shannon Leonard laid out all of the items that would be needed in terms of variance requests. And then also to the point of the design, the Planning Commission does have some ability to allow larger or smaller signs that is within their purview. So they did also look at the design as well as some of the variance issues. Thank you.
Okay, Mr. Riccardi.
And when this kind of thing has come up in the past, whether it's city planning or landmarks, if they don't want to take jurisdiction of the sign and they want to leave it to the Board of Zoning Appeals, they haven't denied it. They've kicked it back. They've dismissed it. They've indicated to Building and Housing that they're kind of like giving up their jurisdiction that's set out in the code, but it hasn't been denied. So, I mean, I guess that's the sticking point here is getting over a specific denial of the application.
Yes, and also the way it's written up here, it's written up as the variances are still listed. And then there's another line for because City Planning Commission denied it. So I feel like the write-up could direct us in a better direction by just having that they are appealing the City Planning Commission and not listing the variances. So that's kind of where we are with this. This is very confusing here. Is so we've already upheld the city planning's denial of this, and so is there any reason to move forward in granting these variances? So, and I'm not getting too much clear direction here because it seems like this is maybe a first time situation. So I'm not sure what to do.
Madam Chair, could I ask a question? It says 34102, the Planning Commission, no building permit shall be issued by the city without design approval by the Planning Commission for development projects which meet the following criteria. And I'm wondering what was the reason that this had to go to Planning Commission to begin with? Is it in a design review district?
Yes, it is in a design review district, and also signage that is larger than the allowable square footage has to go to Planning Commission for approval as well.
that isn't in this part of the code. It may very well be in another part of the code. I'm not questioning that, but it wasn't written up that way. So if it's the design approval, I can't answer. I have a different opinion than Mr. Riccardi, but I don't know whether I'm right or not.
Well, let's do this. We've already upheld the city planning's denial. Mr. Donovan put out a motion to approve the variances as they're listed here. So I would say we, go ahead and vote on that. And then if the fact that the sign has to now go back to City Planning Commission for review and it gets denied, that might be the end of it. But I'm just gonna wing it here because we're not getting clear direction. And so I feel like we have a motion and a second floor. So we'll vote on that. And then as it makes its way through building and housing, we'll find out what happens with that. But I'm not really sure what else to do here.
Madam Chair, this is Liz. So to Lori Wagner, it sounds like also that as the chairwoman stated, we could grant the variances today, and could we remand it back to city planning for the design review? Is that something? I know we remanded things before in the past, but we would be stating that we're granting the variance for the height and size, but that we're acknowledging that design review still has to occur.
I suppose that's possible. Like I said, we don't know what Planning Commission was considering, whether they were just considering the design or the whole sign itself. And I don't know, we'd have to review the code more carefully to see if they're required to also approve the sign, the size, the height. I just think it would be best for the board to vote on these variances, just so there's a record and we can determine at that point. I think if in fact the Planning Commission didn't feel it was appropriate for it to decide whether a sign this large should be allowed, then if the board says that it should be allowed, Planning Commission may want to reconsider their approval of the design. But I don't have enough information on either what the code says or the background of this to know.
The city planner did testify that design review and planning commission both denied the sign and the design of it as it stands right now. So we do have that information. Am I correct, Sharonda?
That is correct.
I suppose it's possible that if the board wanted to grant the variances for the height and the size, that the applicants could submit a different design. I don't know.
Madam Chair, we have Alana Faith with her hand raised.
Ms. Faith.
Madam Chair, I'm interested to know what alterations or changes, reiterations of the sign design took place by the appellant based on the denial from the planning board. Have they worked with the city planner? What have they done to alter the specifications for the sign to try and come within compliance to the code?
I don't think they did. That's why they got denied. If they were working with the planner, they wouldn't have submitted an 80-foot, sign to get approved. So I don't think that happened. I think they wanted to see if they could get this 80-foot sign approved.
Right. That's sort of my point. So, it seems to me that there was a lack of effort on trying to be compliant with the code. So, I just wanted to be clear on that.
I did feel the city planner was implying we get the final approval from you. It was like we stated earlier, the decision was forwarded to you guys for your expertise.
And Madam Chair, to the appellant, if you are denied today, that means you won't get a sign. So do you want to go back to the drawing board, if you will, to work with city planning to try and make modifications so that you're not so extremely out of code compliance?
I feel like the decision should be with you guys, as you guys have more expertise as the original zoning commission plan. We made the original sign. Actually, there was a lot of revisions before we even got to the original board. Like the original sign was bigger, brighter, and it was like completely like vertically facing the wall. And then so our changes were like tilting it to each direction, so it's and having it like a very intense dimming, and there's like the lights are special LEDs so they don't refract away from the sign. So like you ever see those privacy screens on cell phones where you can't see it from different angles? It has some of that technology built in to reduce the visibility from where you don't want it to be seen. So we have done we've made numerous improvements, and we would like to leave it up to you guys.
So in essence, you've made all the modifications that you're willing to make.
That I can think of at this time.
Okay. All right. Okay. Thank you.
Any other questions, board? If not, I think Mr. Donovan had a motion on the floor unless he wants to change that motion. But we had a motion and a second. Mr. Donovan, would you like to keep your motion on the floor?
Yeah.
Okay.
Madam Chair, I do have one more question. Does the board, to Lori, does the board have the authority to grant a variance from code section 341.02, as that may solve the whole question?
No, I have answered this as best I can, which is that I don't know what the answer is. So that's why I'm thinking it's better to allow it to proceed, and we can argue about that later if the board grants approval. I don't know.
Okay, so I guess the question would be, am I taking out section 341.02 from the resolution? Are we granting a variance for that today? Because that's in the adjudication.
The board hasn't granted a variance for anything yet. So, no, I think the board ruled on the administrative appeal. They need to rule on the variances.
Okay.
We need a vote.
Ms. Barnes?
No.
Ms. Faith?
No.
Mr. Donovan?
Yes.
Ms. Britt?
No.
Calendar 21-93 is denied. It'll be ratified next week, and we will send you a letter. I guess to Lori Wagner, do they need to make another motion, or is this essentially denied?
It's denied.
They made the motion and it was seconded and voted on, so it was denied.
Okay, the motion failed and the variance is denied. It'll be ratified next week, and we will send you a letter.
All right.
Thank you. Next case, Thurman, I believe.
Yes.
Ms. Faith? All right.
We bounce back to Thurman. This is case number 21-113 at 2451 Thurman Street. Luz Pelot and Paul Stammies, owners, propose to erect a 26-foot by 50-foot 3-inch 3-story frame single-family residence with a 2-bay attached garage in a B1 two-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 5.
Thank you. Mr. Donovan?
Sorry about that. Everyone who's going to testify for this case, I'm going to read a statement. I'm looking for a response of I do with your name and address. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
Yes. Wesley Harper with Horton Harper Architects, 812 Huron Road East, Suite 305, Cleveland, Ohio, 44115.
Thank you. Next.
Yes, I do. Donna Gregonis with Tremont West Development Corporation. And our address is, wow, I should know my address. It is 2406 Professor Avenue in Cleveland, 44113. Thank you.
Thank you. Next, anyone else?
Matthew Moss with the Cleveland City Planning Commission. And I do.
Okay. Matt, if you could speak up, I'm having a hard time hearing you here.
Will do.
Anyone else? Last call on the history.
Thank you, Mr. Donovan. This property was originally zoned general retail in 1929. In 1988, it was changed to two-family. In the Building and Housing Records Room in 1910, a permit was issued to erect a dwelling addition. 1917, there was an addition again and alterations and repair. And then there was 1983, a permit issued to correct violations to a dwelling on the site. There are no variances on file. And then in the Acela system, we found that there was a cleanup payment applied to the property, vacant lot cleanup payment applied to the property. And that's all that I have. Back to you, Madam Chair. Oh, I'm sorry, one more thing. I did receive an agent authorization from the owner authorizing Wesley Harper to act on their behalf.
Great, thank you very much. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting area variances from the garage placement, maximum gross floor area, minimum lot size, rear yard, and distance requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
Thank you, Ms. Wagner. Maurice, quick summary, please.
Sure. Also, Ms. Faith had her hand raised.
Ms. Faith, is that from earlier, or did you want to say something?
Sorry, that is from earlier, and I was delayed in unmuting myself.
Sorry. Okay, I thought I heard a noise that it just came up.
Yeah.
Yeah.
No,
So we're looking at.
I just messaged you, Maurice, but that's.
Oh, okay. I got the tones confused.
Yeah, that's different situation. So, okay, I'm muting myself. We're moving on.
Yeah, so we're looking at the garage placement, the fact that it's in the front half of the lot instead of the rear. We have a floor area variance and also the rear yard variance and a distance adjacent to an adjacent main building.
Thank you. Okay, Mr. Harper, go ahead and present the case.
Thank you, Madam Chair. We've got our presentation here for the project, and so as mentioned, we're at 2451 Thurman Avenue, just south of Jefferson Avenue in Tremont. And so the owners of the property currently own the property that backs up to West 7th Street. And so we've been working with them for the past several months to design this project and go through the process. So we've been through the block club where we were approved, as well as Tremont Economic Development Committee supported the variances as well. The site you can see here is on one of the currently vacant parcels along Thurman, and Thurman is a rather tight right-of-way, and so there's been even despite that, there's been a fair amount of development over the years in a similar fashion and scale to what we're proposing here today, as well as garage layout and site plan in general. So you can see here context imagery. At the top left, we're looking north on Thurman. The open space to the right is the property. As we move to the upper right, we're kind of a bit north of the property, which is on the left in this view. And then at the bottom left, we have the view of the property. And so basically that telephone pole that you see in the bottom left is give or take the property line of the project. And so obviously a very tight site. This is our zoning submission document that shows our setbacks. Yeah, there we go. And so what we're proposing is a 12'7" setback relative to the property line. And the reason we are working with that number is that, you know, we typically want to see 24 feet for a dimension to back out into a street or an alley. And so that 12'7" plus the dimension of the sidewalk and the dimension of Thurman gets us close to that 24 feet. And so that was kind of the starting point of the site layout. In addition to, you can see at the bottom of the property, the bottom left of the property, we show a ramp sloping up towards the first floor. The idea of this home is that the owners would be able to age in place. And so they're very conscious of handicap accessibility into the house. And so if this house were moved closer towards Thurman, it would minimize the ability to ramp up to the first floor. Another variable that we were contending with is the need to have some outdoor space in the rear of the property. And so with the setback being what it is in the front, we're kind of left with a 10-foot, between 9 and 10 feet of patio space there. So the other setbacks, we've got 3 feet to the south and then 4 feet to the north. You know, typically we usually go to a 3-foot setback on that north side as well. But as you can see, the existing home is right on the property line. And so the 4-foot setback does still allow maintenance of the home over the long term, even though we would be asking for a variance in this case. The home to the north, there's a driveway between us and the existing structure. So, you know, that variance isn't needed to the south. And again, this is, you know, kind of a typical new construction project on Thurman. These are typically 3 stories. You know, we do usually work hard to get the garages set back further. In this case, it just wasn't feasible with the requirements of the buyer and the dimensions of the property. Next.
Sorry, some technical difficulties there.
No, it's fine. Here you can see, we'll just have a couple views of the project when looking from Thurman. At the base to the bottom right, you can see that we are ramping up from the sidewalk, you know, getting a good amount of landscaping into the areas in front of the entry, but still keeping sight lines for pulling out of the garage. Instead of doing what some projects do, you know, doing a single 16-foot wide garage door, we're doing 2 8-foot wide garage doors that have a large amount of glazing. So it kind of lightens up that pedestrian experience there. Up above on the second floor, you can see we have a kind of built-in balcony there, and then on the third floor, there's one as well. And so the way that this building is configured is that the taller portion is towards the taller house to the south, and the step down portion is towards the shorter house to the north. So we're trying to be sensitive where possible here. You know, we do know this is a 3-story building going into some areas that have smaller homes. Next. Here's a view a little bit further south. You can see we're splitting the slope of the structure so that it basically drains towards the middle, which minimizes the height to the east and west. Next. 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 And so here's a material palette. Not sure how critical it is to zoning, but
it's not.
Yeah. We've been through the neighborhood process. It has been submitted to HDRS. I'm not really sure where it stands with them. Director Collier has taken a look at the project as well. And as far as as far as I know, is supportive of the current layout. So if there's any questions, I'd be happy to answer them.
We have Matt here. You can chime in from City Planning.
I believe we have Matt Moss.
Yeah, I was calling Matt.
Yeah, thank you, Madam Chair. So the Housing Design Review Subcommittee took a look at this. Our recommendations for approval to the director were the front yard setback either be 3 feet or 20 feet. The concern here is that if a car, just given this driveway depth, if a car were parked perpendicular to the street, that it would be blocking little sidewalk there is and extending into Thurman. So that was our main recommendation in terms of the design. We also recommended that the front entry be pulled closer to the street and differentiated from the front-loaded garages. This is a really tight lot. It's difficult to fit a standard home here without a front-loaded garage. But our recommendations really are design, and so don't really relate to many of the variances beyond how they might be modified by the design recommendations that we made through design review. So those are staff's recommendations. Happy to answer any questions you may have.
Great, thank you. Donna, would you like to chime in now?
Yes, thank you. Good morning, Madam Chair and members of the board. So it was the understanding of both the Block Club and Economic Development Committee that most of the variances requested are related to the small size of the lot. And the South of Jefferson Block Club approved the variances requested. And that there was some concern over the home being constructed so close to the neighboring homes, but the builder has experience in this and has assured that nothing will happen to the neighboring homes by using metal plating to protect the neighboring residences. And the Tremont Economic Development Committee voted in support of the variances in question as well, and they had unanimously approved them. Thank you for your time.
Thank you, Donna. Board, any questions?
Lori did have her hand up.
Yes,
I don't know if that was from earlier.
Oh, okay.
All right, this was written up as a single family house, and I'm looking at the slide on the screen and it says 2-family. So which is correct?
The architectural drawings are correct.
So you're requesting a 2-family. I have a little bit of a concern about this. The 2-family, of course, is allowed in the district. I'm wondering if it seems like a possibility that a neighbor could object to this as a 2-family when they maybe are not objecting as a 1-family, just as far as density and stuff. I think I would probably leave that to the applicant, but it would be safer if you think there's any potential challenges to this, to re-advertise it appropriately, because it does seem like even though that's allowed, that whether there's 1 family here or 2 might be a factor that someone could consider in whether to oppose or support the variances.
Yeah, I was just going to ask because it is the actual 2-family district, so it is allowed. But you're saying because it was advertised as a 1-family that someone could bring that up later?
Right. That's the concern I would have. But I think I would defer to the appellants to let them decide if they want to take that risk.
Yeah,
Madam
thank
Chair,
you.
Go ahead. Sorry,
thank you. I believe I mentioned that in the local presentations. I can't be 100% sure, but I think the fact that it is within a 2-family district, that I'd be comfortable dealing with any sort of repercussions that would come from that. This seems to happen so often with the write-ups from the building department coming down to zoning, and I frankly missed it on the write-up too. So, but Donna, I saw you had your hand up there too. I don't know if you have any more comment there.
Yeah, go ahead, Donna. Since the Black Club unanimously supported it, do they know this is a two-family, correct?
Donna Gergonis had her hand raised as well. Donna, you're muted.
Yeah, I was just
Thank you.
calling on her.
Sorry.
Yeah.
Thank you.
Yeah.
I was waiting to be officially called on. Thanks again. So I wanted to make it known that in all of my notes and every meeting that I attended, it was clear that this was a two-family residence because they did state that they would be using this, as a two-family home because they didn't intend to rent it out, but they might at some point because the couple does plan to age in place in here. So they wanted to leave that opportunity available. And I do know that the neighbors knew that, and the Economic Development Committee absolutely was aware of that because I have that in my notes and their notes as well. So
Great.
thank you. Thank you for verifying. That's very important, though.
Thank you.
Thanks, Donna.
So I think we're okay on that, Lori. Thank you for bringing that up. I missed that as well.
Madam Chair,
Yes.
if we could ask Mr. Riccardi if the write-up would be any different, particularly section 355.04B. If you note there, it does say two-family use shall not be less than 4,800 square feet. And for the record, the description at the top of the notice of nonconformance did say single family, but we do see that language in section 355.04B. So if we can just confirm that there would be no new code sections, if Mr. Riccardi can tell us that off the top of his head, that would be great.
It is true that all the variances are the same, whether it's a one family or a two family house. It is the applicant's appeal, and it's the notice of nonconformance does go to the applicant. So the applicant filed it as a one family, but we can make it a two family now, and all the variances are the same.
Great. Thank you, Mr. Riccardi. Board, any questions or comments?
Just some basic things. What are we doing for fire rating, given the proximity to the neighbors? And since they're aging in place, is there a contingency for elevators, or how's that being handled?
Yes. The fire ratings would be to the Ohio Building Code for this project. And so I believe that's a 1 hour fire rated wall between the northern property line and the home. In terms of the aging in place, there is an elevator proposed for the project.
Great. If there are not any other questions, Madam Chair, I'll go ahead and make a motion.
Yes, please.
Okay. Years ago, I consulted on the design of a home on Thurman, and it's a extremely tight lots there. So I think these variances are pretty typical of this area of Tremont. Given the testimony we've heard today from city planning and from the Tremont West Development and from the architect acting in behalf of the homeowners, I move that we go ahead and approve calendar number 21-113.
Second.
Second.
Thank you. Call the roll, please, Ms. Kukla.
Thank you, Madam Chair. And that is with the understanding that section 341.02 is
We
not
cannot
being
grant.
correct. So I shall call the roll. Ms. Barnes, is she still on here?
Yes, she's still here.
Ms. Barnes? Okay, I will continue. Mr. Donovan?
Yes.
Ms. Faith?
Yes.
Ms. Britt?
Yes.
Calendar 21-113 is granted, and it'll be ratified next week, and we'll send you a letter.
Okay, thanks, everyone.
Thank
Thank
you.
you.
I think we got one more, right?
Thank
Ms.
you.
Faith?
Finally today, Madam Chair, we have calendar number 21-117 at 607 East 102nd Street. Betty Wilson, owner, proposes to erect 45 linear feet of 4-foot high chain link fence in a B1 two-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinance as stated in the agenda and the public record, of which there is one.
Thank you. Mr. Donovan?
Everyone for this case, will you kindly raise your right hand? I'll read a statement. I'm looking for a response if I do, with your name and address. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
Yes, I do.
Your
My
name?
name is Betty Wilson, 607 East 102nd Street, 44108.
Thank you. Next.
Harvey Wilson, I do. 642 East 102nd Street, Cleveland, Ohio, 44108.
Thank you. Anyone else? Hearing none, last call. On to history.
Thank you, Mr. Donovan. There's been no change in the zoning since 1929. In the Building and Housing Records Room, I found a permit was issued in 1922 to erect a one-story garage. There are no variances on file, and in the more recent history in our Acela system, in 2015, a permit was issued, or sorry, a violation notice was issued regarding fire damage. And then in 2020, October of 2020, a certificate of disclosure was issued stating that the authorized use of the property is single family. And that's all that I have, Madam Chair.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting an area variance from the fence requirements of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
Thank you. Maurice, quick summary. I think this speaks for itself, though.
Yeah, I would just have a fence permit here, and they're not allowed to have a chain link fence in the front yard.
So is what I'm seeing
Sorry,
here
flies in here.
is, yeah. Okay, so they want to bring it up.
So I will say this. Let me make this one comment first. I drove down this street, took these pictures. I have never seen a street with so many front yard fences. There's a lot of front yard fences in this neighborhood, both chain link and decorative. So I would say that there is a precedent for this already. And that's all I'll say for the moment.
Great. Thank you, Maurice. Okay. Ms. Wilson, would you like to present your case, please?
Yes, the reason why I need a fence to go around to the front of my house, it's been a lot of problems with people cutting across my yard. And I just spent a lot of money for my scrubbing thing to get my yard fixed right. And instead of them going the sidewalk, they cut across. And if I go to the door and say something, it's a whole lot of problem. I am 81 years old. I can't get out there fighting with these people. They'll say, go in the house, old lady, or shut up. So it's really creating a big problem for me. And eventually somebody is going to get hurt. And I don't want my sons and them to get involved. I don't always tell them what's going on because I don't want them to, get in trouble with these people. And they don't have no respect, no matter what I say. If you call the police, by the time they get there, everything is, the person walking across the grass is gone. So it's creating a big problem for me. It's making me uncomfortable to live in my own house.
Mm-hmm. It's just because you're on the corner lot. There's a lot of cutting through.
Right. And
The
then
corner
it's,
house. Mhm.
right. And then on the other corner, them people got fence all the way around their house.
Madam Chair, you can even see in the picture across the street. There's another house with the low chain link fence across their front. And I also have to say that Ms. Wilson takes wonderful care of her house. It really spectacular. It looks really great.
Wonderful. Board, any questions or comments?
Looks like Mr. Wilson had his hand raised back there.
Oh, Mr. Wilson, you'd like to say something?
Yes, I am her son. I am her oldest son, and I am responsible for all of her landscape. And
Oh, well, good job.
Good job, yeah. Good son.
So the house was a terrible wreck. So like she said, we've spent money trying to maintain the property and to beautify her home. And it's causing problems with the neighbors. It's some unruly kids that live across the street. And they're just so smart-mouthed. And as she was saying, I don't want to be too quick-tempered with them because it will create a problem. But to consider this fence being put up around her front yard will create us not being able to have to say anything to those people, and it would be a great help for her.
Thank you, Mr. Wilson. Board, questions, comments?
Just a quick question to the Wilsons. Is the intent to keep the fence that now goes against the house on that on the corner there? Are you going to keep that division if you continue the fence around to the front, or is your plan to remove that?
No, I want to keep it.
Okay, all right. Madam Chair, I think this is really a safety concern for Mrs. Wilson. And, you know, we've heard testimony like this before from difficulty with neighbors, and we want to keep her safe. So I move that we go ahead and approve this variance in this situation.
Thank you, Ms. Faith. Can I have a second?
Is it a black vinyl fence or?
No, it's not. Well, the existing one is not. Let's put it that way.
It would help with maintenance. They wouldn't have to paint it if it was black plastic coating.
Ms. Wilson, what kind of chain link fence were you looking to get?
What kind is it?
It's the kind that like the existing fence around there already. Contract people that have tried to pull the permit was fence one, Great Lakes fence. So we already paid $1,326, and we paid that April 26th. They just have not been able to pull the permit.
Correct. So, so you want to continue what you already have there to the front?
Yes.
Okay, Mr. Donovan.
Whatever.
I think in this situation, to keep it consistent with what exists is probably reasonable.
Okay, we had a motion. Can I have a second, please?
Second.
Thank you. Call the roll, please, Ms. Cooper.
Ms. Barnes?
Okay.
Mr. Donovan?
Yes.
Ms. Faith?
Yes.
Ms. Britt?
Yes.
Calendar 21-117 is granted. It'll be ratified next week, and we will send you a letter.
Thank you so much.
Thank you so much. I
Thank
really
you.
Thank you.
Yeah.
have a good day.
Stay safe.
You too.
That's the last case.
That is the last case.
Just wanted to make one quick informational statement about the previous case. This is a case in point of exactly why I'm always against having the home so close to, building so close to the property line. I mean, because the house to the north here or to the south is right on the property line, it actually negatively impacts the new house that's going in.
Right.
And so that's why I'm always so adamant about not building that close to the property line. Anyway.
Thank you for that.
Was that a new house or is that an existing home?
It's probably an old existing home. I doubt we would have ever approved something like that. But, we often get variance cases asking for much smaller side yards, and that's one of my pet peeves of not granting them, is how
Sure.
it affects the neighbor.
Yeah.
And
And sometimes we do it in a situation where we have a lot split that creates the condition to which the variance is needed.
Right.
And I think that was an existing house, since the architect was addressing the height difference in the plans.
All right, old business 1 through 3.
Without objection.
Without objection.
Thank you. And then we have affirmation for calendar number 18-203. They need more time for construction drawings. Without objection?
Without objection.
All righty. That's it.
Okay.
All right. Enjoy the rest of your week, guys.
Thank
thank
you.
you.
You too.
Ms. Barnes, I hope you're okay. I see you on there still.
Yeah.
Yeah, I don't know what happened to her. Okay, everybody, thank you.
Bye-bye.
Okay, bye.
Alana. You're
Yes.
muted.
Yeah.
So you want to, let me, hold on a minute. Let me stop the recording and everything here.